Hi, everyone. Welcome to Lawyers Info Hub. Hello. How are you doing? Hope you're fine. Hope you are good. It is a pleasure to create content on this platform. So, today we're looking at cost, awarding cost. Who bears the burden? This is a platform where we talk about law, we talk about law practice, talk about tips for excellent practice. We help bring in people to share their experiences to help you become better in whatsoever you're doing as a lawyer, as a law student, as anyone who is interested in law. So today we're looking at what happens when the court awards costs. Who bears the burden? How do you pay? Um, is it the counsel that will pay? Is it the client that will pay? And just all that pertains to awarding of costs. So I just hope you enjoy today's class. So cost. Many people sometimes feel so bad when cost is awarded and they feel like they have failed as lawyers, they are not doing the right thing, they felt embarrassed and all of that. See, things like this happen. So you must open your heart, you must open your mind to things like this. But it also means that you must strive to avoid it. But eventually it happens. It's not something you kill yourself or something that you want to fight or something you feel was done without some considerations. You have to still accept it, and if you think it's above the board, there are ways to go about it. So cost, as an excellent lawyer, as a smart lawyer, as a lawyer that should be very diligent. It's important that we do the right things at the right time. Costs are like penalties that is being awarded to people, so that there won't be a repeat of that. Where there's a default, where there's a disobedience, where there is someone is trying to do something outside the prescribed time. In law practice, there's always time for doing everything. The rules are there to help guide you on when to do things. Things are not just done anyhow. You don't wake up in the morning to do things. You just don't wake up and say, I can do anything whenever I want. I'll find my pleadings whenever I want. I'll do everything as I want. It's not done that way, because anyone who does things as they want is someone who's not under control. And our practice is what controlled by the rules. So the rules prescribe what should be done and how it should be done. So friends, in practice, cost is inevitable for someone who is not diligent, for someone who feels they can do anything they want at any time. When you are being briefed by a client, I've done videos, preliminary things you need to ask. If, for example, that matter is being given to you or was being handled by another lawyer and you're just coming in, there are basic questions You ask. When the file is being given to you, you look at, well, have they filed the pleadings? What stage is the matter? Are there things that are supposed to be done that are not done? So as a new lawyer who is handling the matter, you now take steps to put in those things that are not there. Now, sometimes you inherit a matter and you see that the pleadings have not been filed. And you now have to go to the court, apply for certified to or to for a search, understand, to see the proof of service, when were you served, and how many days you're in default. You make application for extension of time before you regularize the process, you pay the default fee and all of that. So these provisions are in the rules to make people to be diligent. But at the same time, you see counsels who are not still diligent in doing their work. And sometimes this causes delays in the administration of justice. Now, court can award costs. Court can award costs when you fail to do things at the right time. Now, for example, court can award cost on you where maybe you file a process a day before court sitting, to which the court will see it as a way to truncate the day's proceedings. Court can award costs where, for example, the court has adjourned 2 months earlier for trial, and you come on the day of trial to tell the court that you have an application or you want to amend, or the court might oblige you, but it's on terms of cost. The court can award costs on you where the court has adjourned for maybe application or something and you're not ready. You come to court and say, my Lord, I forgot my file, or I'm not with the file, or someone just, I'm holding the brief off, and it just told me that just to hear application, and it's the application, and you're not with the file. Sometimes in court, you see lawyers come to court without their file, say, my Lord, I'm in 3 different matters. I didn't know this matter was coming up. Only for me to open my diary to see it's coming up, and they're not with the file, and nothing can be done. In that instance, the court can adjourn. The other lawyer can ask for cost for wasting their time. Some people leave so early to go to court, wasting what they're supposed to do have done in the office time. Time is money. So these are instances where court can grant the court can grant cost. Maybe the court has you amended your processes, and the court has ordered that consequential amendments be done. And you, the amendment, has not even reflected the amendment, or the other counsel is there to do the consequential amendment. The court might award cost. Yeah, the court might award cost. Now, it also cost is also different from default payment. Default payment in terms of, I've earlier explained that maybe you took over a matter, and you need to pay. You've not filed your plea. You now check that the party have not filed their pleadings. I go to court to file your plea. You see that they will ask for default fees. The default fees are provided for in the rules of how much you pay every day you're in default. It's called default fees. They're kind of cost, yes, but the cost I'm talking about in this video today is cost the court awards on a defaulting party in the course of proceedings. So when a court adjourns for a matter and there's a reason why the matter will not go on, and the reason is from the default or a fault of a counsel, the other counsel can ask for costs. And sometimes you can also understand that even though nobody asks for cost, the court can award costs on a counsel for wasting his time. Yes. The court had adjourned for report of service, or the court had adjourned for the hearing of an application. And in that last adjournment, the court found out from its record that a particular party had not been served, maybe the third defendant. I said court directs back that the hearing of this application is dependent on the service of the third defendant. And you come back a month after, 6 weeks after, and the court still finds out that you have made no effort to even serve the third defendant. Not like a bailiff have been contracted or been, you have approached a bailiff to serve, or maybe the bailiff have not been able to serve, or you have no excuse whatsoever to have preferred to the court to say, this is why I've not been able to take this step that you directed I should take 6 weeks ago. So in that instance, sometimes the court will like, you wasted my day, and I could have fixed another matter, rather than fix yours, and you wasted the day. So sometimes you see judges award costs on counsel, for wasting their time. Some of that time, the court will even give hints to the other counsel. Like, are you asking for costs? Sometimes it's not like directly, there can be a hint. Or some of that time, the other counsel can stand up and say, my Lord, I'm not opposing the application for adjournment, but it shall be on terms. So you have to also be aware that some lawyers, you're in a case with them, they're always looking for ways for cost. So if you are in that situation and you're already aware that this particular counsel likes cost, so you have to step up. Not like they are doing it against you, but it's just for you to step up. You see that some people, they have a way to go around things. They have a way to delay matters. They'll keep filing an application upon application. Sometimes when there is a ruling, at the end of the ruling, court can award cost. At the end of the judgment, court can award cost. Yes, you bring an interlocutory application, maybe on jurisdiction or issue of abuse of court process, anything you want to bring, and then the court finds that your application is not there's no merit in your application. The court will dismiss the application and sometimes award cost for wasting the time of the court, going back and forth. The time the court would have moved on to trial is still doing ruling interlocutory applications here and there. So these costs can come in different forms, but when it comes, who bears the burden? We have seen instances where the Supreme Court awarded costs personally against counsel, where the court will note that this cost is to be paid by the claimant counsel. It has happened. We have several of those instances in the law report. You read them where the court awards costs personally on counsel, believing that the counsel either did not advise their clients very well. You see, sometimes they call like, why would you even file this suit? It's a frivolous suit. This is a suit filed to waste the time of the court, to waste the time of everyone. So sometimes you see the court angry, and they file they hold and the rule that a particular counsel of a particular party would pay the cost. But generally, costs are paid by the party, not a counsel. Yeah, but sometimes you see that when the court stand finds that the negligence is not on the part of the party, but on the counsel. Court can order, you may not, might order that the cost be paid personally by a counsel. Now, many lawyers are in the habit of when court awards cost, they don't pay, they want to appeal it, they want to, there are things to do, they want to bring application for variation of the cost. You cannot bring an application where you feel the cost is outrageous. You can bring an application for the court to vary it, but in many instances, courts don't like varying. Yeah, they will come and tell you that they can't vary it, they can't do this and all that. Yes. So what many people do is they meet their fellow counsel, um, you know, to say, okay, please, this is sometimes people do it, sometimes other people tell you it's not ethical and all that. But I've seen where people they'll meet the other counsel, like, okay, the 50,000 naira cost, please, I have 30,000. This is counsel to counsel. But most times these people the counsels don't agree. You must pay everything. So when you're in the habit of defaulting the orders of the court can, invoke its powers and you lose the right of audience. It is in the rules. So when the court makes an order for award and you fail to pay, the other counsel can raise it. My lord made an order on the so date of this, and counsel has failed to pay. My Lord, I pray that he be denied the right of audience. The court can deny you the right of audience. What that means is that you're not permitted to talk because you are in default of the order of the court. So the burden, beyond the fact that it's the party that pays for cost, unless the court direct the counsel to pay personally. But the effect of disobedience of not paying that cost affects the counsel. Your right of audience may be what? Denied. You come to court and you will not be able to talk because you do not have a right of audience. So the burden, as much as the financial burden, most times rests on the party, but they also affects the counsel, who, if the cost is not paid, cannot talk or cannot even be heard in court. So it's also the duty of a counsel to keep reminding party of that the cost. For example, if maybe you're to amend your application, if you are to amend your pleadings and you need certain documents from your client and you keep writing them, please bring these documents, we need to amend, time is going. At the end of the day, they didn't bring it and the court slams cost on you. The clients know that this what I'm saying is important. For example, the court has adjourned for trial, and you keep telling your clients this is on so date, and that day your client comes up with the excuse of I'm not feeling fine, I can't come, and there's no medical evidence for you to present to the court that the client cannot come. So when the court awards such cost, you've done your part as a counsel. So I always advise friends, I always advise my colleagues to avoid costs at all costs. Anything you need to do it timeously. You need to respond to applications, respond to it timeously. You need to, whatever it is you need to do, you need to file a process. Don't file it on the day of the matter. Just file it. Let the court the other party be aware of what you're doing. Sometimes people do these things to ambush the other party or to frustrate or truncate a proceedings. So you have to avoid that part. Sometimes many lawyers are known for being in default. And when a court or a judge knows that you're always a party in default, it's not a good thing. So awarding, of course, the court has that power. Is provided for in the rules. Yes, it's provided for in the rules. So when it happens, don't feel bad. Do the right thing. Many people have but for a very important thing is that in appealing on cost, you need a leave of court. You don't just appeal because you need a leave of court to appeal on cost. Very important. Very, 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 very important. So who bears the burden? The burden is being borne by both the lawyer and the party. The party bears the financial burden. But for the council, whose party did not was not able to pay, the cost bears the burden in that his right of audience is what denied. So these are things we need to know. These are procedures you need to know. So anything you need to do, you do it on time. Are there steps you need to take to put your house in order? The housekeeping rule, put your house in order so that the next day the matter can go on. So that sometimes people come to court and they now notice in court that the application they're supposed to argue is not in the court in their file, and they start looking for. I know in that, are you not supposed to look at these things before coming to court? So there are errors we can avoid. There are things we can avoid to avoid, costs being awarded against us. So let's be up and doing. Let's look at our files. Let's study our files before going to court. Are there things we're supposed to do? I've talked about the lawyer's diary. Many people have diaries, but they don't know what to do with it. They don't know that the diary is beyond taking adjournment dates. You can use your diary for scheduling. You should be able to know your schedule. What am I supposed to do? A matter have been adjourned 6 weeks time, and there are things the court has ordered hearing notice. This is one of the things many people get caught for, hearing notice to be issued and served, and you didn't make any effort to meet the register of court for the issuance of the hearing notice. You didn't make any effort for the hearing notice to be served. And on the next adjourned date, you want to proceed when you have not obeyed the order of the court. So when the other counsel asks for cost, don't say they are not doing the right thing. They are within their right to ask for costs. Very important thing I need to also say that peradventure the other party has asked for cost. The court will always want your response. Many people, sometimes it's advisable that if you know you are really in default and the court is determined to award cost for you, you can give a figure. Say, my lord, I concede to cost of 10,000, or I concede to the cost of 5,000. But when you feel the reason for the delay is not my own duty, it's not my own, it doesn't fall in my place, or I tried my best and it didn't work, or some of that extenuating circumstances that happen, not because you didn't do what you're supposed to do, or you tried doing what you're supposed to do and it didn't work, you cannot make an argument and provide the reasons why you feel the court should not grant that cost. And say, my Lord, I pray that cost be in cost. Many people don't understand this phrase, cost be in cost. It means let this cost my Lord wants to grant be in the cost of the proceedings. Because each party is making putting in efforts in the hearing of man, expenses have been handled by party. So let this cost be in cost. So that's what we mean. So when there is an application for cost, you must be ready to respond. Many people do not know how to respond, and that is why their response is not always, sometimes the court does not listen, is not tenable. That is why the court will insist on granting cost. We've seen where people have asked for cost of 1 million naira, and in response, the other party will come and state, my Lord, this is what happened. I've done my own part. Even if what I'm supposed to do, I didn't do it, cannot stop the proceedings of the court. You can also say, my Lord, I was in default, but this other party is also in default. If he had done this wouldn't have happened. Okay, you can also say, my Lord, peradventure you needed, you applied to the court for record of proceedings. My Lord, I couldn't get the record of proceedings. That is why I couldn't do this. And the court will see that you made an effort, and the fault was not from your own side, because you took steps to see that thing is done. But there are some administrative lapses on the part of maybe the registrars or something. So when you are making your argument against cost, you must present higher reasons why the court should not grant cost. Because when you provide reasons that are not tenable, that are not higher than that of the person who is requesting for cost, the court will overrule you and grant cost. So you have to be wise to know, is this cost deserving? If the cost is deserving in that instance, state an amount which is very low, the court might accede to that. But sometimes when you argue and know that you are at fault and you're still arguing, the court will slant that cost on you. So you have to be wise. A lawyer, beyond knowing the law, you have to also have good reasoning. You have to understand what to do at every point. Many people don't understand what they're supposed to do. Many people just feel they keep arguing against cost. When you know that cost is deserving, what you do, you present the figure. My Lord, I concede to the cost of 5,000. And it's easier for you rather than allowing the cost to give a cost of 50,000. So it's wisdom. Wisdom helps you to know what to do and what not to do. So, friends, it's been an amazing time. We've looked at cost. When can court grant cost? We looked at instances. We've looked at default fees that is kind of a different from cost, because default fees, like when you're supposed to do something, thanks for filing of a process, maybe you didn't file. The days you're in default is provided for in the rules and you pay. They call default fees. We looked at costs the court can grant, who bears the burden. We've stated that unless the court specifically makes provision or others, that the council pays the cost personally, the cost is borne by the party. We've looked at as much as sometimes the party bears the cost, depending on the instance the court gives, the council also has the burden in the sense that his right of audience can be denied. Where the other party raises this issue, my lord, there is still non-compliance to the payment of cost. And I pray that you deny the right of audience of the claimant counsel. Court can what agree to that application and deny you access, right of audience, and because you are at that point in disobedience of the orders of the court. So, friends, it's been an amazing time talking about cost, awarding of cost, who bears the burden. And we also talked about where the other party raises an application for cost. Your response to that application, you must know what to say. You must profile higher reasons why the court should not grant the cost. And if you know that you are in the other parties indeed entitled to the cost, you must make just profile an amount. You can state a very low cost amount. The court might just add something more and grant it, or the court might agree with you. But if you keep insisting that the cost should be in cost, the court might give a very high figure. So you must know how to balance it. You must know when you are really in default, when you are at fault, what to do. And when you feel that it's not a fault of yours, that the matter couldn't proceed for the day, you also know what to say. So it's been an amazing time in this class today. I just hope you learned something, because this law thing is not really one-sided. You must know it from different angles. And we learn every day. When you stop learning, you stop dying. So, friends, it's been an amazing time. If you're yet to subscribe to this channel, please don't hit the subscribe button. Subscribe to this channel. For our returning subscribers, like, I don't know what to say. I appreciate you. I love you. I thank you for always coming, stopping by, checking the content, checking the channel. I'm super, super, super grateful. Thank you. I appreciate you so much. I appreciate you so much. I wish one of these days we meet everyone to, know, one-on-one. But I know one day it's gonna happen. Just share this video to your friends, to your mentors, to your mentees. You might learn something, one or two, from this video. Do take care of yourself and know that the sky can be your starting point. Bye.